A standard civilian divorce operates within a single, predictable boundary. You live in a state, and that state's laws govern how you split your assets, figure out custody, and move on. But the moment you or your spouse wears a uniform, a massive layer of federal military law drops right on top of those state rules. The entire landscape changes. If you don't account for both systems, a service member can easily lose their legal voice while deployed overseas. On the other side of the table, an uninformed spouse can sign away a lifetime of military healthcare coverage with a single signature. Failing to address that federal layer when dividing a military pension can cost a family hundreds of thousands of dollars in retirement pay long after the divorce is finalized. A military divorce is a volatile collision between two complex systems. Navigating the overlap is the only way to protect a family's future. To untangle this, we start with what the state actually controls. Virginia law dictates where you file based on your residency and sets the legal grounds for the divorce itself. The state also handles the physical division of your property and maps out child custody based on the best interests of the children. But federal law supersedes the local judge. Take the Service Members Civil Relief Act, or SCRA. It stops a state court cold. The SCRA acts as a federal pause button. It legally prevents a local judge from finalizing a default judgment against a deployed member who physically cannot be in the room. Then there is the 20-20-20 rule. This diagram shows the exact math required to keep full military benefits. You need 20 years of marriage, 20 years of creditable service, and a 20-year overlap between the two to guarantee a former spouse lifelong TRICARE healthcare. That federal math is completely inflexible. If your marriage overlap falls short of that 20-year mark by a single day, those healthcare privileges vanish. State laws govern the daily reality of separating a household, but these federal rules form a rigid shield that a local family court judge has absolutely no power to bypass. The friction between these two systems becomes obvious when it's time to calculate child and spousal support. A significant portion of a service member's take-home pay isn't a traditional salary. It comes in the form of the Basic Allowance for Housing, or BAH, and Basic Allowance for Subsistence, BAS. Both of these are federal, tax-free allowances. This infographic illustrates the problem. State family courts are required to take those tax-free allowances and dump them directly into the total calculation for state gross income. This drastically inflates the financial baseline used to determine support. Military compensation simply doesn't map neatly onto civilian tax brackets. State courts have to redefine what actual income means for a serving family. The financial stakes peak when we look at retirement. Under a federal law called the USSPSA, state courts are fully authorized to divide a military pension as standard marital property, but a specific Supreme Court ruling regarding VA disability pay creates a dangerous trap. The court ruled that state judges are strictly forbidden from touching VA disability pay. It cannot be divided in a divorce, no matter what a local agreement says. Here's how this plays out in this chart. Retirees will often waive a portion of their taxable pension to receive tax-free VA disability instead. When that happens, the disability waiver actively eats into the pension, shrinking the exact slice previously awarded to the ex-spouse. Because of a 2017 ruling called Howell v. Howell, a state court cannot legally order the veteran to reimburse the ex-spouse for that shrinking share, even when that share represents years of family sacrifice. A perfectly sound state-level agreement can be financially gutted years down the road if a future federal disability claim alters that pension. The only real protection is negotiating specific fail-safes into the agreement on day one. Untangling a military divorce stretches far past active duty and deep into retirement. If a divided pension pays out, it stops the moment the retiree dies. The Survivor Benefit Plan, or SBP, acts as the necessary insurance to keep that income flowing to a former spouse for the rest of their life. But the SBP operates on a rigid timeline. You have exactly 1 year from the date of the divorce to lock in that election. Missing that single federal deadline is a mistake that cannot be fixed. It overrides whatever intentions you wrote into your state decree, leaving a surviving spouse with absolutely nothing. This dual-layer system is designed to account for the unique realities of military service. Achieving true protection requires securing those federal rules before the state ink ever dries.